Hello everyone. Hello everyone. Welcome to EduTap. First, can you please let me know if I am audible? If you can see the screen, if I am audible. Is the voice clear now? Okay, now I have changed the setting. Am I audible now? Kindly let me know if I'm audible. Hello everyone, welcome to EduTap. I am Arshdeep Kaur and today we will be starting with the lecture on Constitution. It is our first lecture on Constitution for paper 2 of SEBI exam. Today we start with the lectures on the topics of paper 2. We have done the lectures for paper 1 and now we will start with the subjects of paper 2. The Constitution has been given 20% weightage, which is very important for your exam, and we will be having 4 lectures. Today, we will be dealing with the preamble, the part 1 and part 2 of Constitution, part 3 of Constitution. So we will be covering all the important provisions of the preamble, part 1 and part 3 of the Constitution through MCQs. So before I start, I would like to tell you that EduTap has come up with test series and live crash course on this examination for both the phases, phase 1 and phase 2. The test series will include the chapter-wise tests, the sectional tests and the full-length tests. It will be very helpful for your revision for the examination. And the EduTap is also coming up with live crash course. We will be having 60 plus sessions. They will be live sessions, 2 hours each. It will include the live classes, the test series, and you also get the one-on-one mentor support. We are running a limited time offer. So if you want, kindly refer to the link in the description below. Today is the first lecture on the Constitution and it is being streamed on YouTube as well. We will be having 60 sessions like these. So those of you who have not enrolled yet can do. So let's start with the lecture. Today, as I have told you, we are starting with Constitution of the India. Constitution of any country is the mother of all laws. The ethos of this, any country, any law cannot go outside the scope of that constitution. The constitution is like a tree branch out of which other laws emanate, right? And India, being one of the largest democracies, has one of the lengthiest constitutions. It is one of the lengthiest constitutions in the whole world. Before we start with any statute, you must read the preamble first. Preamble tells you about its objective, about its philosophy, that why that statute has been enacted. So that is why we are starting with the preamble. We will read the preamble first. So let's begin with the preamble. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, which justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and the integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give ourselves this Constitution. So, the Constitution is very important part of any statute. Let's start with the MCQs now. Question number one. What was the exact constitutional status of the Indian Republic on 26th January 1950 when the constitution was inaugurated? So the constitution inaugurate hua tha when it came into force. What was the status of the constitution? Was it a democratic republic, a sovereign democratic republic, a secular democratic republic, a sovereign socialist democratic republic, a sovereign socialist secular democratic republic? So the answer is B. It was sovereign democratic republic. If we read the explanation, Constitution of India came into force on 26 January 1950, right? On 26 January 1950, India had the constitutional status of sovereign democratic republic. The other two words, that is secular and socialist, they were added later on. They were added by the 42nd Amendment Act 1976. So today, what is it's today? It is sovereign, socialist, secular, democratic republic. Socialist, secular being added by the 42nd Amendment. Before we move on, I would like to tell you a little about what are these words. We use these words very often, and what does it mean, right? So the words are sovereign. First is sovereign. Sovereign means कि इंडिया किसी के भी नीचे नहीं है. It is an independent. It's sovereign. It is not under anybody, right? That is sovereign. Socialist means that the resources of the government, they are distributed among all according to their needs and not equality, right? This is what is socialist. Secular, I know you must everyone know that it is that India respects all religions, and but it does not have any official religion of its own. Democratic, it is a form of government with which the sovereignty lies with the people. And republic is a nation जिसका जो head होता है, that is elected. It is not a monarch, it is not hereditary, it is elected head, right? So this is republic. तो अगर हम आज देखें तो आज सोवरेन सोशलिस्ट सेकुलर डेमोक्रेटिक रिपब्लिक, दिस इज द स्टेटस ऑफ इंडियन कॉन्स्टिट्यूशन टुडे. Question number 2. Which of the following was not inserted in the preamble of Constitution of India through the 42nd Constitutional Amendment Act 1976? Socialist, secular, dignity, integrity, none of the above. The answer is option C, dignity, right? Dignity was not added. In fact, dignity is not mentioned in the preamble at all. The 42nd Constitutional Amendment Act 1976 changed the description of India from sovereign democratic republic to a sovereign socialist secular democratic republic, and also changed the words unity of the nation to the unity and integrity of the nation. So the three words that were inserted, they were socialist, secular, and integrity by the 42nd Amendment Act 1976. Question number 3. The idea of preamble was borrowed from which of the following? Was it the UK, Ireland, Russia, USA, or Australia? The answer is D, USA, right? So it was taken, it was borrowed from USA. Constitution of USA was the first written document with the preamble. So Constitution of USA was the first written document जिसका एक preamble था. And we have also borrowed the idea of preamble from USA. Question number 4. Who prepared the preamble of the Indian Constitution? Dr. B.R. Ambedkar, Dr. Rajendra Prasad, Jawaharlal Nehru, Mahatma Gandhi, or K.M. Munshi? The answer is C, Jawaharlal Nehru. The base of the preamble was the objective resolutions moved by Jawaharlal Nehru. The objective resolution was moved on December 13, 1946 by Pandit Jawaharlal Nehru, which provided the philosophy and the guiding principles from framing the constitution and later took the form of preamble of the constitution. So जो objective resolutions Jawaharlal Nehru जी ने propose किए थे, which were for the framing of the constitution, which provided for the philosophy and they had the guiding principles कि constitution को हमने कैसे बनाना है. They were later on accepted as the preamble, right? So and later took the form of the preamble. So it is Jawaharlal Nehru who prepared the preamble because the base of the preamble is the objective resolutions, and the objective resolutions were passed by Pandit Nehru on December 13th, 1946. Right? Next question. Question number 5. Which one of the following pairs is correctly matched? We have to tell which one is correctly matched. Republic, head of the state is hereditary monarch. Sovereign, constitution rests on the people's will. Democratic, constitution does not recognize legal supremacy of another country. Secular, state is without any religion of its own. Right, the answer is D. Only D is matched correctly. State is without any religion of its own. If we read the explanation, the term republic signifies that there shall be an elected head of the state. As I've already told you, republic means it will have elected head of the state. Sovereign means constitution does not recognize the legal supremacy of any other country. India is not under anybody. The term democratic means a government established by constitution which gets its authority from the will of the people. And the term secularism means the state which has no religion of its own, no official religion, right? So the answer here is secular. Secular is mentioned correctly. State is without any religion of its own. Question number 6. So as I've told you, republic, the head of the state is elected. Sovereign means India is not under anybody. The constitution does not recognize the legal supremacy of any other country. Democratic means the government established by the constitution which gets its authority from the will of the people. And secularism, state is without any religion of its own, but it respects all of the religions because India has positive secularism. It does not practice negative secularism. Question number 6. Assertion. Constitution of India was adopted on 26 November 1949. Reason. Bulk of constitution became operative on 26 January 1950, which date is referred to as the constitution as its date of commencement. So which of these is correct? All of you have guessed it right. It is A. The right answer is option A. Let's read the explanation. The Constitution of India was prepared by the drafting committee. This we all know. Constituent Assembly, and it adopted, enacted, and enacted Constitution on 26 November 1949. So, if the question is कि वो adopt या enact कब हुआ था, the answer will be 26 November 1949. Some of the provisions came into force on that day. कुछ ऐसी provisions थी Constitution की जो 26 November 1949 से ही लागू हो गई थी. While the others came into force on 26 January 1950 when the Constitution came into force. Now I've mentioned Article 394 also. Article 394 में लिखा हुआ है कि which were the articles जो कब से start हुए थे, कब से in force हुए थे और rest of the Constitution कब से हुआ था. If we read Article 394, this article and Articles 5, 6, 7, 8, 9, 60, 324, 366, 367, 379, 380, 388, 391, 92, 93 shall come into force at once, and the remaining provisions of the Constitution shall come into force on the 26th day of January 1950. So ये वाले articles हैं, they came into force on 26 November 1949, and the other articles they came into force on 26 January 1950, which is known as the commencement of the Constitution. These were the important articles, like they were related to the citizenship or the oath of the president, the definitions. So वो उसी time शुरू कर दी गई थी, and the rest of the Constitution it came into force on 26 January 1950. तो इससे कंफ्यूज नहीं होना है. 26 November 1940, and if it is commencement or came into force, it is 20 January 1950. Right? Let's move on to the next question. The correct nomenclature of India according to the preamble is it sovereign, secular, democratic republic, sovereign democratic republic, sovereign socialist, secular democratic republic, sovereign secular socialist democratic republic, or sovereign secular socialist? Right, the answer is sovereign socialist secular democratic republic. As we have read the preamble, starts with we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. Right? And we have also done the meanings of these words. So it will be option C, that is sovereign, socialist, secular, democratic republic. Question number 8. The first session of the Constituent Assembly was held. So when was the session of the Constituent Assembly held? Right? The answer is option A. On 9th December 1946, the first meeting of the Constituent Assembly of India took place in New Delhi's Constitutional Chamber, in which Dr. Satyanarayana Sinha was enacted as a temporary president. तो डॉक्टर सचिदानंद सिन्हा को टेम्पररी प्रेसिडेंट बनाया गया था ऑन द फर्स्ट मीटिंग विच वाज हेल्ड ऑन 9th December 1946. तो कॉन्स्टिट्यूएंट असेंबली थी. इट प्लेड टू रोल्स. एक तो वो कॉन्स्टिट्यूशन मेकिंग बॉडी थी और एक वो लेजिस्लेटिव बॉडी भी थी which was मेकिंग अदर लॉज अदर देन द कॉन्स्टिट्यूशन. जो लॉज बनाने थे वो भी कॉन्स्टिट्यूएंट असेंबली बना रही थी. So when it acted as the legislative body, तो उसके प्रेसिडेंट थे जीवी मावलंकर, राइट? तो उसके प्रेसिडेंट थे जीवी मावलंकर when it was the legislative body acting as a legislative body, and when it was a constitution making body, president was Dr. Rajendra Prasad, right? Who was the president? If it was constitutional body, if it was the constitution making body, it was Dr. Rajendra Prasad, and if it was the legislative body, it was G.V. Mavalankar. So the first session was on 9th December 1946. Question number 9. Which was the last to be adopted in the Constitution of India? Preamble, fundamental rights, directive principles of state policy, citizenship, or union? Right. The answer is option A, preamble. Preamble was the last one that was adopted in our constitution. The preamble is based on the objective resolution moved by Jawaharlal Nehru in the Constituent Assembly on December 13, 1946. This we have already done. The resolution was adopted on January 22nd, 1947. Preamble was the last one to be adopted by the Constituent Assembly after a long debate. तो कॉन्स्टिट्यूशन सारा बन चुका था एंड इन लास्ट हमने जो है प्रियम्बल को अडॉप्ट किया था. सो प्रियम्बल वाज द लास्ट वन व्हिच वाज अडॉप्टेड बाय द adopted in constitution, right? Question number 10. Till now, the preamble of the Constitution of India has been amended how many times? Never, once, twice, thrice, or 4 times? Right, this was an easy question. You have guessed it right. The answer is B. It is only been amended once. The 3 words which were added by the preamble to the Constitution by the 42nd Amendment 1976. This we have already done. 42nd Amendment 1976 में socialist, secular and integrity words insert किए गए थे. And this is the only amendment till now to the preamble. It has been clarified by the Supreme Court of India that being a part of the Constitution, preamble can be subject to constitutional amendments exercised under Article 368. पहले ये भी बहुत डिबेट चलती थी कि is the preamble a part of the Constitution or not. तो ये Supreme Court ने clarify कर दिया था that yes, it is a part of the Constitution and it can be amended. However, the basic structure cannot be altered. Therefore, it is considered heart and soul of the Constitution. So it has only been amended once, and which was during the 42nd Amendment in 1976. Question number 11. How does the Constitution of India describe India as? Federation of States and Union Territories, a union of states, or a federation nation? This also, you have guessed it right. The answer is C, a union of states. So India is a union of states. If we read Article 1, India, that is Bharat, shall be a union of states. So the answer is option C. The states and the territories therefore shall be specified in the first schedule. So states and territories जो हैं वो कहाँ mentioned है? They all are mentioned in the first schedule of Constitution. The territory of India shall comprise, क्या कुछ included है in the territory of India? Territories of the states, all the states. The union territories specified in the first schedule, जो भी union territories हैं, they are mentioned in the first schedule, and such other territories as may be acquired. So India is a union of states. Question number 12. Power to carve out new state is vested in the Parliament, President, the Council of Ministers, States Reorganization Commission, or the Governor. Right. The answer is A. Parliament has the power to carve out the new states. If we go to the Article 3 of our Constitution, formation of new states and alteration of areas, boundaries, or names of existing states. So who has this power? It is the Parliament. Parliament by law. It is written Parliament by may by law form a new state by separation of territory from any state, or by uniting two or more states or parts of the states, or by uniting any territory to a part of any state. Either they can form a new state, or they can increase the area of the state, or they can diminish the area of the state, alter the boundary of the state, alter the name of the state. All these powers they vest with the Parliament. ये powers सबकी किसके पास है? Parliament की. There is a proviso, let's read it. Provided that no bill for the purpose shall be introduced in either house of the Parliament except on the recommendation of the President. So जब तक President recommend नहीं करेंगे तब तक this bill of either diminishing or altering, this cannot be introduced in either house of the Parliament. Unless where the proposal, and this is and, so ये दोनों conditions have to be fulfilled. एक तो recommendation of the President, the second one being unless where the proposal contained in the bill affects the areas, boundaries, or names of any state. The bill, जो bill है, that affects the area of the boundaries or the name of any state, the bill has been referred by the President. The bill has been referred. The word is referred and not permission here. So if it is referred by the President to the legislature of that state for expressing its view thereupon. Recommended by President and means plus जो स्टेट की बात हो रही है, it has been referred to that state and उस स्टेट के legislature ने अपने views रखे हैं, अपने views बताए हैं उस बिल पर, right? Within such period as may be specified in the reference, or within such further period as the President may allow. Either with such period जो President ने specify कर दिया है और आगे allow कर दिया है increase करने के लिए, and the period so specified or allowed has expired, and if that period which has been specified और जो allow किया गया था जब वो खत्म हो जाता है, तो it is deemed कि वो मान गए हैं, they have agreed to it, right? Explanation in this article in clause A to E, जिसमें alteration diminish ये लिखा गया है A to E, state includes a union territory, but in the proviso state does not include a union territory. जब हम union territory की बात कर रहे हैं तब जब हम state की बात कर रहे हैं proviso में, तब union territory is not included. Explanation 2. The powers conferred on the Parliament by clause A includes the power to form a new state or union territory by uniting a part of any state or union territory to any other state or union territory. So it includes both. Question number 13. If a new state of Indian Union is to be created, which one of the following schedules of the Constitution must be amended? First, second, third, fifth, none. Right. The answer is first. The first has to be amended. It is actually first and the fourth both will be amended, but since it was only the first in the options, the answer is first. The first schedule of the Indian Constitution deals with the list of states and union territories of India. So the first schedule of the Constitution should be amended for creating a new state or a union territory. ये कहाँ पर लिखा हुआ है? This has been mentioned in Article 4. Laws made under Article 2 and 3 to provide for the amendment of the first and the fourth schedules and the supplemental, incidental and consequential matters. Any law referred to in Article 2 or 3 shall contain such provisions for the amendment of the first schedule and the fourth schedule as may be necessary to give effect to the provisions of the law and may also contain such supplemental, incidental and consequential provisions, including provisions as to the representation in the parliament and in the legislature or legislatures of the state or states affected by such law as parliament may deem necessary. No such law as aforesaid shall be deemed to be an amendment of the Constitution for the purposes of Article 368. It is not to be deemed as a constitutional amendment. So at Schedule 1 and Schedule 4, Schedule 1 deals with the states and the union territories, and Schedule 4, it deals with the allocation of the states in the Council of States. So seats ke numbers, they are also going to change. That is by Schedule 4, and name is also going to change. So Schedule 1. Both of these have to be altered. Next question. Democracy is a government of the people, by the people, and for the people. Who said this statement? This is an easy one. Right? You all have guessed it right. The answer is Abraham Lincoln. So Abraham Lincoln has said that democracy is a government of the people, for the people, and by the people. It means that democracy is a form of government in which the rulers are elected by the people. यहाँ पर जो rulers होते हैं, they are elected by the people. The citizens of the country elect the government to rule the country, and the elected government work for the welfare of the people. Question number 15. Which committee was formed for the determination of the boundary of India and Pakistan? Which committee was it? The answer is Redcliffe Committee. The answer is Redcliffe Committee. Redcliffe Committee ने boundary बनाई थी India and Pakistan की, because the head was Redcliffe. That is why it is known as the Redcliffe Committee. The boundaries between the two dominions were determined by a boundary commission headed by Redcliffe. So the answer is Redcliffe Committee. Next question, question number 16. I'm sorry, this is a repeated question. This we have done. Next question. K.M. Munshi was related to Constitution Drafting Committee, Preamble Committee, Public Accounts Committee, Union Power Committee, or none of the above. K.M. Munshi was related to what? Right again. The answer is option A, Constitution Drafting Committee. He was active participant in the freedom movement ever since arrival of Mahatma Gandhi in India. In the Bardoli Satyagraha, he supported Sardar Patel. For a brief period, he joined the Swaraj Party, but later returned to the INC on Gandhi's behest at the time of launch of Salt Satyagraha. Munshi was one of the ad hoc, he was on the ad hoc flag committee also. So he was also on the ad hoc flag committee that selected the flag of India in August 1947. And on the committee was drafted the Constitution of India under the chairmanship of B.R. Ambedkar. The Constituent Assembly, in the starting, it had 7 members, and K.M. Munshi was one of them, and B.R. Ambedkar was the chairman. I've provided you with the list of all the 7 members. Just in case any such question comes, you should know that the other members were. Right. So on 29th August 1947, the drafting committee of the Indian Constitution was appointed, and the 7 members: Aladi Krishna Swamy Iyer, N. Gopala Swamy, B.R. Ambedkar, I've told you, he was the chairman of the drafting committee, K.M. Munshi, Mohammad Sadullah, B.L. Mittar, and D.P. Chetan. Right. So B.R. Ambedkar was the chairman, and K.M. Munshi was a member of the drafting committee to make the constitution, the Constituent Assembly. Question number 18. Who considered the rights to the constitutional remedies as very heart and soul of the Indian Constitution? So who said this? The constitutional remedies, they are the heart and soul of the Indian Constitution. Right? The answer is option C, B.R. Ambedkar. Baba Sahib Ambedkar called the rights to constitutional remedies as the heart and soul of our constitution, because it is the only right that makes the rest of the rights effective. So if किसी का भी right, fundamental rights right is being violated, so they can move to the Supreme Court or High Court under constitutional remedies, right? Constitutional remedies. So Baba Sahib Ambedkar called the rights to constitutional remedies as the heart and the soul of the Constitution. If any fundamental right is violated, we can directly approach the Supreme Court or the High Court of a state. Right? Next question, question number 19. Which of the following is a bulwark of personal freedom? Bulwark of personal freedom कौन सी रिट को बोला जाता है? Bulwark का मतलब होता है a strong support or protection, right? So which of these writs is it? Right? The answer is B, habeas corpus. Habeas corpus is a bulwark of personal freedom. It is a legal writ through which a person can seek relief from the unlawful detention of him or herself or of another person. So it is the habeas corpus which protects you against the unlawful detention. That is why it is also called the bulwark of personal freedom. Next question. Question number 20. Which part of the Indian Constitution deals with the fundamental rights? Part 1, 2, 3, 4 or 5. Which one is it? Right. So the answer is option C. Part 3 of the Indian Constitution deals with the fundamental rights. Articles 12 to 35 contained in Part 3 of the Constitution deal with the fundamental rights. I have mentioned all the types of the rights which are mentioned in the fundamental rights. They are right to equality from Article 14 to 18. Right to freedom, they are from Article 19 to 22. Right against exploitation, Article 33-34. Right to freedom of religion, Article 23 to 28. Right against exploitation, 23-24. Cultural and educational rights, Articles 29 and 30. And right to constitutional remedies, Article 32. So, Part 3 deals with the fundamental rights in our constitution. Next question, question number 21. Which constitutional amendment deleted the right to property from the list of fundamental rights? Fundamental rights earlier, it used to be right to property used to be a fundamental right. By which amendment was it deleted? Most of you are saying option C. Right, so the answer is option C. It was the 44th Amendment 1978. The 44th Amendment of 1978 removed right to property from the list of fundamental rights. So today, right to property is mentioned in Article 300A. It is not a fundamental right anymore. It is a constitutional or it is a statutory right, right? The right to property is now considered to be one or is considered to be not only a constitutional or a statutory right but also a human right. I just quoted the Supreme Court. The right to property is now considered to be not only a constitutional or a statutory right but also a human right. It is no longer a fundamental right but it is a constitutional right. Next question, question number 22. Which amendment to the Constitution inserted a new Article 21A providing right to education in the Constitution? 85th, 86th, 87th, 88th, or 89? Again, you have guessed it right. The answer is 86th Amendment. So the 86th Amendment 2002 provided right to education as a fundamental right in Part 3 of the Constitution. So when it was inserted in 2002 by the 86th Amendment to the Constitution. If we read Article 21A, right to education, the state shall provide free and compulsory education to all the children of the ages of 6 to 14 years in such manner as the state may by law determine. So it is Article 21A. Free and compulsory education provide की गई है to the ages from 6 to 14 years. And this was inserted by the 86th Amendment 2002. Next question. Which of the following is not a state under Article 12 of the Constitution? Article 12 of the Constitution provides for the state. Which of these is not a state? NCERT, Union Public Service Commission, Municipal Corporation, none of the above. Right again, the answer is NCERT. NCERT does not constitute a state according to Article 12 of the Constitution. Under Article 12, the control of the government does not necessarily mean that the body must be under the absolute direction of the government. It merely means that the government must have some form of control over the functioning of the body. Government का कुछ control हो उस पर, that is state. Just because a body is a statutory body does not mean it is a state. Both statutory as well as non-statutory bodies can be considered as a state if they get financial resources from the government and the government exercises a deep pervasive control over it. तो एक organization state है या नहीं है उसको हम कैसे check कर सकते हैं? If the financial resources they are from the government and that the government exercises a deep pervasive control over it. Example, state includes Delhi Transport Corporation, ONGC, electricity boards, but does not include NCERT as neither it is a substantially financed by government nor is the government's control pervasive, right? So the answer is NCERT according to Article 12. Next question. Which article of Indian Constitution is related to the doctrine of self-incrimination? तो self-incrimination कौन से आर्टिकल में प्रोवाइड किया गया है? प्रोटेक्शन अगेंस्ट सेल्फ इंक्रिमिनेशन कहाँ प्रोवाइड किया गया है? इज इट आर्टिकल 19, 22, 20 clause 1, 20 clause 2 or 20 clause 3? No, it is not option C. It is E. It is Article 20, Clause 3. If we read it, protection in respect of conviction for offences. First, you must remember, यहाँ पर protection सिर्फ offences के case में दिया गया है, right? Protection in respect of conviction for offences. Let's go through each of these. First one, no person shall be convicted of any offense except for the violation of law in force at the time of the commission of the act charged as an offense, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offense. This is protection against ex post facto law. एक act अगर आज वो पनिशेबल नहीं है, वो एक ऑफेंस नहीं है, और आज अगर किसी इंडिविजुअल ने वो एक्ट किया गया है, अगर आफ्टर 2 days अगर वो एक ऑफेंस बन जाता है, देन दैट पर्सन ही कैन नॉट बी प्रोसिक्यूटेड फॉर दैट ऑफेंस, राइट? एंड इट ऑल्सो सेज नॉट बी सब्जेक्ट टू अ पेनल्टी ग्रेटर देन दैट। जो जिस दिन उसने वो ऑफेंस किया है, उस दिन जो पनिशमेंट होगी उसी दिन के अकॉर्डिंग उसको पनिशमेंट मिलेगी। हो सकता है ड्यूरिंग हिज कोर्स ऑफ ट्रायल और एनीथिंग दैट इज इंक्रीज्ड, जैसे रेप के केस में हुआ था, निर्भया के केस में। बट इफ इट इज इंक्रीज्ड, तब भी जो पेनल्टी होगी दैट विल बी अकॉर्डिंग टू दी दैट डे जिस दिन उसने वो किया था ऑफेंस, राइट? लेट्स रीड इट अगेन, नाउ इट विल बी क्लियर टू यू। No person shall be convicted of any offence except for the violation of law in force at the time of the commission of the act charged as an offence, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of that offence. So this is known as protection against the ex post facto law. Clause 2. No person shall be prosecuted and punished for the same offense more than once. This is protection against double jeopardy. So this is he shall not be prosecuted and punished. And punishment is important. So if he was acquitted या appeal हो रही है, then it is a different issue. But if he was prosecuted and he was punished for the same offense, he cannot be prosecuted and punished again. This is known as the protection against double jeopardy. Third is no person accused of any offense shall be compelled to be a witness against himself. So the first and the foremost is he should be an accused. If he is an accused, he cannot be compelled to be a witness against himself. उसको नहीं बोला जा सकता कि वो अपने against ही गवाही दे. Right? So he cannot be compelled to be a witness against himself. This is known as the protection against self-incrimination. So this article is 20 clause 3. Right? I hope this is clear to all of you. Question number 26. Backwardness under Article 15 clause 4. Which backwardness is mentioned in Article 15 clause 4? Must be social and educational, must be social and not necessarily to be educational, must be economic as well as social, must be political, economic, social, or none. Right. So the answer is option A. It must be social and educational. If you read the Article 15.4, you will find that it talks about the social and educational backward classes. Prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. Clause 4. Nothing in this article or in clause 2 of Article 29 shall prevent the state from making any special provisions for the advancement of any socially and educationally backward classes, right? It is socially and educationally backward classes of the citizens or for the scheduled castes and the scheduled tribes. The and is important. This is that class should be socially and educationally backward. Both have to be satisfied. Socially and educationally backward classes of the citizens or for the scheduled caste and the scheduled tribes. So that is why the option was A. It was not C. It is must be social and education. Question number 27. Which article of the Constitution abolishes untouchability? This is an easy one. You must know this. Is it Article 18, 19, 20, 17, or 21? Right. The answer is Article 17. Article 17 abolishes untouchability. Untouchability is abolished and is practiced in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with the law. So this is the first constitutional offense that we have read. It is Article 17 is a constitutional offense, right? It is punishable under law. So the answer is option B, that is Article 17. Article 17 deals with the has abolished untouchability, evolution of untouchability. Next question, question number 28. The appropriate writ issued by the Supreme Court to quash the appointment of a person to a public office is mandamus, prohibition, quo warranto, or habeas corpus. It is quo warranto, right? So quo warranto writ is issued by the Supreme Court. Let's read the explanation. It means by what authority? क्या authority है आपकी? So through this writ, the court calls upon a person holding a public office to show under what authority he holds that office. If it is found that the person is not entitled to hold that office, he may be ousted from it. Right? So the answer is quo warranto. It is issued by the Supreme Court to quash the appointment of a person to a public office who is not entitled to that office. If it is found that the person is not entitled to hold that office, he may be ousted from it. So that is why the option C is correct. Right? It is the writ of quo warranto. Question number 29. Constitution guarantees that all the citizens shall be equal before law. It is provided in which of these articles? Is it Article 11, 12, 13, 14, or 15? Right again, the answer is option B, Article 14. Let's read it. Equality before law. The state shall not deny to any person. Any person means it is available to the citizens as well as the aliens, right? So any person, equality before the law or the equal protection of the laws within the territory of the India. Equality before law means no special treatment is to be given. That is what is equality before law. And equal protection of law is that all persons have the same rights and the same treatments who are in same circumstances, under similar circumstances, right? The answer is Article 14, equality before law. Next question. Which one of the following is the guardian of fundamental rights? Legislature, executive, political parties, judiciary, or none of the above? Right, the answer is judiciary. So judiciary is the guardian of fundamental rights. If the fundamental rights, if your fundamental right is being violated, then you can move to the court, right? They are enforceable by the court. Body which acts as the guardian of fundamental right is the Supreme Court. The court protects the fundamental rights of the citizens from being exploited. The Supreme Court, as the guardian of fundamental rights, can declare any law null and void if it violates fundamental rights. It also has the power of judicial review. It can declare any law null and void अगर वो outside fundamental right या in violation of fundamental right जाता है. And at the same time, they are also guardian of the fundamental rights. अगर किसी का fundamental right is being violated, then they can move to the court, right? So the answer is option B, that is the judiciary. Question number 31. Under which article the state may make special provisions for women and children? Article 15.4, 15.3, 15.2, 15.1 or 15.5. Right, the answer is option B. So option B is 15 clause 3 provides for to make this provides that the state can make special provisions for both women and children. This provides for the discrimination in favor of women and children, right? If we read it, nothing in this article shall prevent the state from making any special provisions for the women and children. So it is 15 clause 3. I would like to quote the Supreme Court here. 15 clause 3 is a recognition of the fact that for centuries women of this country have been socially and economically handicapped. In order to eliminate the socio-economic backwardness, the clause has been framed, right? So why this clause was framed? To eradicate the social and economic backwardness, right? And it provides that the state can make the special provisions for both the women and the children. Next question, question number 32. Question number 32. At present, there are how many freedoms under Article 19? 7, 6, 8, 10 or 9? Everyone is right here. The answer is option B. So at present, there are 6 fundamental freedoms in Article 19. Protection of certain rights regarding freedom of speech, etc. All citizens shall have the right. All citizens means these are only given to the citizens and not the aliens. These are only given to the citizens. To freedom of speech and expression, to assemble peaceably and without arms, to form associations or unions or cooperative societies, to move freely throughout the territory of India, to reside and settle in any part of the territory of India, to practice any profession or to carry on any occupation, trade or business. There are 6 fundamental rights that have been given in Article 19, right to freedom. So the answer was option B, that is 6. Question number 33. If an Indian citizen is denied a public office because of his religion, which of the fundamental rights is denied to him? Right to freedom, right to equality, right to freedom of religion, right against exploitation, or right to property? This will be a bit tricky, so I want you to go through it once again and then answer it. So if an Indian citizen is denied a public office because of his religion, which of the following fundamental right is denied to him? The answer is option B, right to equality. Right? So right to equality is denied to him if he is denied a public office because of his religion. Let's read the explanation. If an Indian citizen is denied a public office because of his religion, he is being denied his fundamental right to equality. It is given in Article 16. Equality of opportunity in matters of public employment. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under this and under the state. Right. So all the citizens in the matters relating to employment or appointment. Here, appointment and employment also includes promotions, pensions, right? This is also being included in this. So it is the right to equality. There shall be equality of opportunity for all the citizens in matters relating to employment or appointment to any office under the state. So that is why the answer was option B. Next question, question number 34. Which of the following fundamental right is also available to a foreigner on the soil of India? So which of these is also given not only to the citizen, but it has also been given to an alien? Is it equality of opportunity in the matters of public employment? This we have already read. So it's not. Freedom of movement, residence and profession, protection from discrimination on the grounds only of religion, race, caste or sex, protection of life and personal liberty against action without authority of law. So the answer to this, you have guessed it right. It is option B, protection of life and personal liberty. The fundamental rights to the protection of life and personal liberty against the conduct without jurisdiction is open to foreigners also on the soil of India. Article 21 of the Constitution enriches this basic right. So it is protection of life and personal liberty. If you want, I can give you the list of all the articles that have been given to the all the aliens. So you can write it down. So these are the articles which I'm going to mention. They are given to the citizens as well as the aliens, but not to the enemy aliens, right? So these are Article 14, Article 20, 21, 21A, 22, right against exploitation, that is Article 23, 24, and right to freedom 25 to 28. So these all articles, they are given to the citizens as well as the foreigners, as well as the aliens, right? Let's move on to question number 35. Which article is referred to as the jewel of the Constitution? Article 123, 31, Article 21, Article 352, or Article 32. So which is known as the jewel of the Constitution? It is option number E, that is Article 32, rights to constitutional remedies. Right, you have guessed it right. It is Article 32. The answer is option E. Option E deals with the rights to constitutional remedies. Let's read it. Article 32 falls under Part 3 of the Constitution that includes the fundamental rights of individuals. It is the very soul of the Constitution and the very heart of it, right? So it is Article 32, the jewel of the Constitution, Article 32. Question number 36. How many types of fundamental rights are provided by the Constitution of India? 9, 8, 7, 6, or 5? So, how many types of fundamental rights are provided? How many types हैं? Right, the answer is B, that is 6. There are total of 6 rights provided in the Constitution. So these 6 are, I have mentioned them also: right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, rights to constitutional remedies. So there are a total of 6 fundamental rights. They are available to the Indian citizens as provided in our constitution, right? So there are 6 fundamental rights. Option D. Next question, question number 37. Which of the following case is known as the fundamental right case? So which of these is known as the fundamental right case? The correct answer is B and not D. It is the Keshav Nanda Bharti case. Keshav Nanda Bharti and others versus the state of Kerala. It was in the year 1973, right? Is certainly one of the leading cases in the constitutional history of India, if not the most important judgment of the post-independent India, and is popularly known as the fundamental rights case, right? So it is known as the fundamental rights case. What landmark judgment hai? This is Keshav Nanda Bharti case. The landmark judgment, it was delivered in 1973. A majority of 7:6, wherein the majority held that any provision of the Indian constitution can be amended by the parliament in order to fulfill its socio-economic obligations that were guaranteed to the citizens as given in the preamble, provided that such amendment did not change the constitution's basic structure. So the parliament can amend the constitution, but it cannot amend the basic structure of the constitution. It cannot change the basic structure of the constitution. The Supreme Court held this in the year 1973 in the case Keshav Nanda Bharti case versus the state of Kerala. So it was also known as the fundamental rights case. Keshav Nanda Bharti case is also known as the fundamental rights case in the year 1973. Question number 38. Which of the following articles of the Indian Constitution provides for the power of judicial review of legislative functions? Articles 13, 17, 18, 19 or 20. So which is it? You have guessed it right. It is Article 13. Everyone has guessed it right. It is Article 13. So Article 13 gives the power of judicial review. The power of judicial review is significantly vested upon the High Courts and the Supreme Court of India. Under Article 13 of the Indian Constitution, the compulsion of judicial review was described in Fundamental Rights in Part 3. Right, so it is Article 13. Article 13 gives the judiciary the power of judicial review. So answer is option A. Next question, question number 40. 39 question, sorry, question number 39. Which of the following set is said to be a golden triangle of the Indian Constitution? Is it Article 14, 15, 16, Article 20, 21, 22, Preamble, Fundamental Rights and Directive Principles, Articles 14, 19 and 21, Article 16, 17, 18. Golden Triangle Indian Constitution में किन 3 articles को बोला जाता है? So most of you were saying D, which is correct. Article 14, 19 and 21. They are said to be the golden triangle of the Indian Constitution. Article 14, 19 and 21 are known as the golden triangle because they are regarded as the fundamental principle for the country's smooth operation. Article 14 addresses the right to equality, 19 the right to freedom, and 21 the right to life and personal liberty. These articles are critical to understanding the concept of the rule of law. Without these articles, the basic principles of the country's smooth running of life for its citizens would be impossible. That is why 14, 19, 21 articles are collectively known as the golden triangle. They are very important in understanding the concept of rule of law. They are the basic principle for the country's smooth running, right? That is why they are known as the golden triangle. Let's move on to the next question now. Question number 40. Article 20, Clause 3 of the Constitution of India guarantees the right against self-incrimination too. This I have mentioned in one of the earlier questions. Is it available to the witness, accused, any person, plaintiff, or none of the above? Right. The answer is in fact option B. So it is available to the accused only. The Indian Constitution provides immunity to an accused against self-incrimination under Article 20, Clause 3. No person accused of an offence shall be compelled to be a witness against himself. This I've explained you, right? So it is Article 20, Clause 3, and he must be an accused. It is only available to him if he is an accused, right? Next question, question number 41. Which of the following states is not included in the sixth schedule of the Indian Constitution? So which of these states is not included in the sixth schedule of the Indian Constitution? Is it Meghalaya or Tripura, Mizoram, Manipur, or none of the above? Right. The answer is option B, Manipur. Rest all of the states, that is Meghalaya, Tripura, Mizoram, they have been included in the sixth schedule. So the answer is Manipur, that is option D. Sixth schedule, provisions as to the administration of the tribal areas in the states of Assam, Meghalaya, Tripura, and Mizoram. These are the areas with the distinct culture, and that is why they have been given this power. They protect the distinct culture of these areas. So the states are Assam, Meghalaya, Tripura, and Mizoram. It protects tribal populations and provides autonomy to the communities through creation of autonomous development councils that can frame laws on the land, public health, agriculture, and others. So इनका system बिल्कुल different चलता है, right? So that is why this schedule is also known as the mini constitution. So if you go through schedule 6, it includes everything, right? So they have been given the power to frame their own laws of land on public health, agriculture. They can develop their councils, they can create autonomous councils also, and they can make autonomous areas also, right? So that is why इस शेड्यूल को मिनी कॉन्स्टिट्यूशन भी बोला जाता है एंड विच ऑफ दीज स्टेट्स आर इंक्लूडेड एज आई टोल्ड यू इट इज असम मेघालय त्रिपुरा एंड मिजोरम Manipur is not included in the sixth schedule. That is why the answer is option B, right? Now we can move on to the next question, question number 42. Who called the preamble as the identity card of the Constitution? This also you should know that who called preamble as the identity card of the Constitution. So the answer to this is N.A. Palkiwala. You are right. The answer is option A. N.A. Palkiwala called the preamble as the identity card of the Constitution. N.A. Palkiwala, an eminent jurist and constitutional expert, called the preamble as the identity card of the Constitution. Right? So the answer is option A. And who called the preamble the key to the Constitution? This also is, I've mentioned, this is Ernest Baker. So Ernest Baker called the preamble the key to the Constitution, right? The key to the Constitution, Ernest Baker called preamble the key to the Constitution. And political horoscope, this was given by K.M. Munshi, right? So it is political horoscope is K.M. Munshi and key is Ernest Baker, and identity card of the Constitution is N.A. Palkiwala. Question number 43. The fundamental rights, they were added by the 42nd Amendment. were added by the 44th Amendment, formed a part of the original Constitution, were added by the Parliament in 1952, were added by the Parliament in 1962. So which of these is correct? Most of you are saying option C. It is correct. It is option C. So they formed a part of the original constitution. When the constitution was made, the fundamental rights were included in the constitution. Fundamental rights is included in the part 3, this we have done, of the Indian constitution, which is also known as the Magna Carta of Indian Constitution. Fundamental rights को हम Magna Carta of the Indian Constitution भी बोलते हैं, right? It is included in part 3. Fundamental rights formed a part of the original constitution, and idea was borrowed by the US Constitution. This also we have covered. So it is also known as the Magna Carta of the Indian Constitution. What? The fundamental rights, right? And they formed a part of the original constitution. Question number 44. Which of the following terms feature in preamble to the Indian Constitution? This also you should know. We have already done it. Secular, fraternity, inclusive, equality, communism. So select the correct answer using the code. Which is it? Right, the answer is option B. 1, 2, and 4 only: secular, fraternity, and equality. Nowhere the word inclusive or communism has been mentioned in the preamble of the Indian Constitution. The answer is B. Preamble of Indian Constitution clearly mentions the words secular, fraternity, and equality, but the words inclusive and communism are nowhere mentioned in the preamble. Secular, fraternity, and equality, they have been mentioned. So that is why our answer was option B, which is 1, 2, and 4 only. So secular, fraternity, and equality. Question number 45. The Indian Constitution has 395 articles, 22 parts, and 12 schedules. 448 articles, 25 parts, and 12 schedules. 395 articles, 22 parts, and 8 schedules. 395 articles, 25 parts, and 12 schedules, or 448 articles, 25 parts, and 8 schedules. So which is it? Which is it? The Indian Constitution has how many articles, parts, and schedules? I'm waiting for your answer. It is not B. No, the correct answer is option A. It has 395 articles, 22 parts, and 12 schedules. Please don't get confused. कहीं कहीं 400 something articles लिखा होता है. It is not. It is 395 articles. Always 395 articles. जब भी एक amendment हुई है, it have been included as जैसे 21A और G, Z ऐसे include हुआ है. So that is why the number of articles आज भी है 395. The articles, if you open the Beer Act, you will come to know it is 395 articles. It is not 400 and something articles, right? So it is 395 articles, 22 parts, and 12 schedules. The Indian Constitution is divided into 395 articles, 22 parts, and 12 schedules, right? Answer is A. Yes, correct. Answer is A. 395 articles, 12 parts, 22 parts, and 12 schedules. So this was the end. This was the last question of today's lecture. We have done the important MCQs of preamble, the part one, that is the union and the union territories and the states, and part three, which was the fundamental rights. We have covered the important questions. So now, if anyone has any questions, any query, don't refer to any books. Always go to the Bear Act straightly. You are advocates. You must know how to read the Bear Act. Always you have to start with Bear Act. Bear Act should be your best friend, right? Whenever you are preparing, always refer to Bear Act. These lectures are going to be in MCQ form. Yes. These are enough. I will tell you that I have framed these questions in such a way कि सारे जो important MCQs हैं they are being covered, right? आप इन्हीं को रिवाइज कर लीजिए. These should be enough. आज हमने सिर्फ preamble part 1 और part 3 ये ही कवर किया है. Any other question anybody has? We will be discussing from the quiz only. Do you want me to frame other questions as well? I can do that for you if you want. हाँ, PDF will be provided to you. Will be provided to you. PDF will be provided to you. This will be sufficient. See, हम जितने मर्जी MCQ कर सकते हैं, there is no limit, right? But what we have done is हमने उतने ही रखे हैं जो important provisions आपके include कर सके. That is why, क्योंकि अब time बहुत कम है. I know that you cannot refer to the Fair Act. आप सारे provisions, सारे articles, सारे sections, सब clauses you cannot read. That is why we are moving like this. Yes, that is to you. Right. So, socialism is an ideology. Socialism में क्या होता है? जो resources हैं, that is in the hands of the government. और government जो है, उसको ऐसे distribute करती है कि जिनके पास वो resources नहीं है, उनको देती है. Right? So it is not equally distributed. अगर हम equally distribute करने लग जाएंगे, अगर आप Indian scenario लो, ठीक है, अगर हम equally distribute करने लग जाएंगे, तो the richer will get richer, the poorer will remain poorer, right? तो वो ऐसे डिस्ट्रीब्यूट करती है गवर्नमेंट कि वो उनको बेनिफिट करे. ठीक है, सोशलिज्म. आई विल प्रोवाइड यू द पीडीएफ्स. यू विल गेट इट. आई विल गिव इट टू यू. Any other question anybody has, or anything else you want to say? Any improvement, any feedback? If you want to give any feedback, you can also do so. You can, I can also unmute you if you want. So anyone? Right, I'm waiting. If anyone has any query regarding today's lecture, please let me know. Right, then I will end the meeting. So thank you for joining today. I hope this was helpful session for you. Questions more or less same ही रहते हैं. I have gone through the questions अगर आप Dear Act refer करेंगे तो उसमें से बहुत easily you can get out the answers. बहुत straightforward questions होते हैं, nothing tricky. तो उसकी you need not to worry about, right? Anyone else? Any question? Any feedback? Right. So I will end the meeting now. and I will see you tomorrow at 6 with lecture number 2 on Constitution.